also we would contend is an error. Again, this was a very short-term marriage. At the time of the divorce trial, the parties had only been married for 3.5 years. They had been together longer and had resided together and were raising their children, but the actual term of the marriage was 3.5 years at the time of the trial. At that time of trial, the parties had only recently purchased this marital residence, which was in Greenbrier. And unfortunately, there just wasn't a whole lot of testimony at the trial in terms of where source of funds came from, down payments, things of that nature. However, there was testimony on the income of the parties that was not disputed. The husband worked 2 jobs during the marriage to pay the bills. He earned about $50,000 a year. The wife's testimony was that she earned about $19,000 a year. The marital residence was purchased for $218,000 about 2.5 years before trial. The parties owed $205,000 on that residence at the time of trial. And also, unfortunately, there was not really testimony or proof regarding what that residence was worth at the time of trial. The wife testified that she believed the residence was worth more than what they had purchased it for, but that's the extent of the testimony of the value of that property at trial. The
counsel, did you? I don't think your brief included a Rule 7 table, did it?
I don't believe so, but I don't recall without looking.
Don't our rules kind of pretty much require that if property division is at issue?
That is true, but so unfortunately the trial court, and of course I wasn't the counsel at trial court, but the trial court did not make any findings on any of these assets.
That was the next question I was going to have to you is, did the trial court really make any findings of fact?
Unfortunately.
Or make conclusions of fact, I guess.
No. On the award of the marital residence and the equity, the court made one finding of fact out of the 12 factors in 36-4-121, and that was the trial court found that the wife maintained the bills at the residence while the husband was in jail. That was the only fact that was included at all out of the 12 factors. So that's part of the reason, obviously, for this appeal is there really weren't findings of facts or conclusions of laws for either one of these issues. And additionally, as far as the marital residence, it is still financed in the husband's name as well. So effectively, the trial court just failed to divide the marital residence pursuant to statute because it's still in both of the parties' name and not really divided. So that's our issue with the marital residence. With the Lawrence County property, this was clearly purchased prior to the marriage. And again, this is where the trial court found that the parties were living together and raising children together when the husband purchased this Lawrence County property. But that's not the standard. The husband testified that he used his premarital retirement funds to purchase this Lawrence County property, and that was not disputed. And as we know, separate property can become transmuted pursuant to Fox, and that's what the court said, was that this property was inextricably intertwined or commingled, and the court found it to be marital. However, that was not appropriate based on the factors in Mitts versus Mitts. Clearly the property was separate. It was purchased prior to the marriage. So then what we're looking at is, was the wife's contribution substantial, real and significant, to this property such that it became commingled and that she would be entitled to an increase in value? And we would submit no, because the proof at trial did not support that. The wife testified generally that she had helped manage this property in Lawrence County. However, she testified that she had only been to the property occasionally, and that the last time she had been there was in 2019. She could not recall any dates that she had helped assist with anything at the property. She was asked if there was rental income from that property. Her response was, "I have no idea." The husband testified that and provided proof that his family had paid the taxes at that property for 2020 and 2021. So essentially, we have the wife saying that she contributed to the increase in equity in this property. However, the proof just did not support that. So it is our contention that that property would be separate property. It would be his sole and separate property. It would be not subject to equitable division. However, even if it was subject to some sort of equitable division, the court did not provide any analysis of the factors under 36-4-121 of why the wife would be awarded 40% of that equity. That was just a conclusory statement, and that there was just no analysis or no findings. So it's our position that this needs to be remanded for further findings at the trial court. And unless the court has other questions.
The marital residence, the wife was awarded the marital residence, but there was no instruction in the order to convey a deed or anything.
That's correct. No provisions whatsoever to truly separate that property.
Is there a mortgage or a lien on the house? Marital?
There is. And the wife testified at trial that she wanted to either keep the residence or sell it because she could not afford it on paper. So it's my understanding that she did keep it because I don't think she could sell it without there being further instructions on how to sell it or convey a deed.
And the decree, did it say that the husband was to pay and be solely responsible for that mortgage, or?
It did not. I think it was silent on that. However, the husband was in Robertson County Correctional Facility, so we shouldn't assume, but I think it was assumed that the wife would continue to pay for the mortgage.
Thank you.
Thank you.
Okay. We'll hear from you.
Good morning, Your Honor. My name is Laura Adams, and I am the appellee in this. Sorry, first time doing this. I apologize for not having legal counsel, as I cannot afford that. I did not have any issues with the trial court's decisions. Several attempts have been made to come to an agreement between my ex-husband and I. I have offered the Lawrence County property 100%. I offered to take my 40% back because he feels like he was done wrong. He has continuously denied those. He would not come to an agreement. That's why I was essentially set to trial. We tried to do a round table agreement where at no point did I ever ask for his Lawrence County property. However, after several attempts to come to some type of agreement, my legal counsel at that time said we will leave it in the hands of the trial court and the judge. And so that's what I've done with that. Even after, since he is now sitting in prison serving 13 and a half years, I have since then even still offered to give him the 40% back of the Lawrence County property, and he has since denied that. I've offered that to his trial attorney here today, and to his power of attorneys.
Sorry to interrupt you, but let me hear what we're faced with. We're an appellate court.
Right.
All we can look at is what's in the record that's come up from the court.
Mm-hmm.
So I understand what you're saying about the offer stuff made, but that's not stuff that we can consider, because all we can do is look at it and see if we think the trial court got it right or made any errors. So all we can look at is what happened at the trial court, what comes from the trial court up to us.
Yes, sir.
So,
yes, Your Honor.
Okay. I'm sorry, go ahead.
I guess to touch base on that, we were only married for a few years. We were together for almost 12. We had 3 children together. He was previously married and married to another woman most of our relationship, which that's a whole nother. But as far as coming up from the trial court, even though we were only married a short time, we were together 11 years, did live together as man and wife and raised our children together. So at that point, we did get married eventually and then bought our marital home. Marital home is where me and the children currently reside, at this moment. However, the house is in foreclosure at this point, and that house is about to not be anybody's. So if y'all have any questions, I will feel free to answer.
I hear no questions. Thank you.
Thanks.
Thank you.
Hear from the appellant, rebuttal.
Just briefly, I would just agree that most of what was just stated is extemporaneous settlement agreements and negotiations, and what we're looking at is the trial court, and I think it's very clear, just based on the lack of analysis and the lack of findings of fact and conclusions of law, that this needs to be remanded to properly deal with those issues. I don't have anything else, so I'll rest unless there are questions.
I hear none.
Thank you.
Thank you. We appreciate both sides your argument this morning. Thank you for being here. If you would, recess court till this afternoon's